Back now on Triad Today. Last month, if you were watching, and shame on you if you weren't, we were talking with two distinguished guests from the Dummit law firm about a particular topic, which is really taking advantage of the adversarial system. It's there for you. We're going to explain more about that in a second. But next to me, of course, is Clarke Dummit, the founder of the firm, and Jennifer Kuhn is with him. We're going to continue our discussion by picking up with, we were talking about suppression motions last month and how important it is that you have a lawyer, no matter what the case is or what your situation, always make sure you're represented. And sometimes motions are filed and sometimes they're not. Sometimes your Fifth Amendment rights apply and sometimes they don't. But let's pick up with Fourth Amendment rights. When we're in the thick of a case, can you give an example, Jennifer, of where Fourth Amendment rights come into play?
Well, your Fourth Amendment rights actually come into play throughout the case, but most importantly, they come at the initial stop. When an officer makes an initial stop, that's when your Fourth Amendment rights begin. And for example, I had a recent case once where law enforcement has to have a reasonable, articulable suspicion to stop your car. That means it's a legal standard, and that means that they have to be able to articulate something that you are doing that is illegal. I
smell marijuana in your car, or something like that.
Some things along that nature.
They can't just stop you and say, we're stopping you for the heck of it.
Well, law enforcement can stop you on the street just to talk to you. They are regular people, so they can do that. But in order to make a legal stop, when they activate the blue lights of the car, turn on the siren, things like that, they have to have a reasonable, articulable suspicion.
And that comes under the Fourth Amendment. So.
That does come under the Fourth Amendment.
All right, let's talk about cases. Let's go further into this. If there's a case against you where the state may have trouble proving their case. Now, I'm going to give you some prompts here, and I want you to talk about this, either of you, and we'll start with Clarke. Missing witnesses. How does that come into play? Clarke.
Well, it follows up on what we talked about last month. Even if you are guilty, you may want to challenge the evidence. Many times the state is missing witnesses they may need to prove every element of their case. A good example would be in some of the cases where they have lab work that they're trying to get into evidence from the Raleigh SBI.
Right.
They've had a lot of problems in the SBI lately with tainted evidence, with DNA evidence.
That's right.
They're having all sorts of problems down there. They fired some people. So it's entirely possible that the state's not going to be able to get the witnesses they need to get a lab report into evidence.
So you sort of a double whammy. They might not show up with the proper evidence because it might be tainted, and they might not have a witness to talk about the tainted stuff. So it's a double whammy. Let me talk about circumstantial evidence for a second, Jennifer. There's a case against you, whatever, and you're being tried, but circumstantial evidence comes into play. Explain that for us.
Circumstantial evidence is just evidence that doesn't directly link you to the crime. It's evidence that shows that you could be the person who perpetrated the crime, but it doesn't necessarily, there may not be an eyewitness. There may only be, evidence that doesn't amount enough to overcome that burden of proof that the state has beyond a reasonable doubt.
And that goes back to the fact what we talked about last month, which is always good to be represented, because if you don't put up a fight, then you're not able to challenge. You don't want to be convicted on some kind of circumstantial evidence when you're not guilty. Final thing, you made a statement to me in an email one time, Clarke, and you said that a good court fight can sometimes mean a better plea bargain. And you said this happened to you halfway through a case. What were you talking about?
Yes, I tried a case recently, well, not too recently, about a year ago, and we were in the second day of trial fighting every single piece of evidence, and the state was having problems on it, and they knew they were having problems. You can read it in the jury's face sometimes that the case wasn't strong enough, and we ended up working out a plea bargain that the state wouldn't have offered before the trial started, but with a rigorous defense, they ended up making a deal that we said yes to, and my client pled guilty 2 days into the trial with the deal that he thought was better than running the risk, and the state thought it was better than waiting to see the outcome.
Yeah.
So a good fight can result in a better plea bargain.
And when you say a fight, it's a fair fight. You're presenting evidence, or you're opposing evidence, or trying to suppress it. But again, you're getting good representation, and that brings me to the website I want to put up, www.nclawyer.com. If you have any questions about anything, or you or a member of your family or loved one in need of help, and something has happened in your life and you might need some representation for whatever reason, you can give the folks at the Dummit Law Firm a call or go to that website. And to Clarke and to Jennifer, thank you for walking us through these.
Certainly.